So tonight we have Kristi Curry from Survivorship Now, and she is going to interview Margaret Menicucci, an attorney and counselor for Braun and Gresham, on the topic of estate planning. Now at Survivorship Now, we're investigating some of the myths and facts that keep people from getting their estate plans done. If you look at the studies over the last decade, it's really shocking. Consistently, between 50 and 60% of people do not have a will. Why is that? We want to look at that because we at Survivorship Now hear the same things over and over again, and that's why we really wanted to have this webinar for you. So let's learn a little bit about Margaret. She's originally from New Mexico, just like Kristi. She graduated from UT, so that's University of Texas School of Law, and has been a resident of Austin for 25 years. She enjoys teaching negotiation and multi-party conflict resolution in environmental and energy matters at the University of Texas School of Law, and she's currently an attorney and counselor at Braun and Gresham. Her husband is also an attorney, and she's the mom of 2 great teenage daughters. So Kristi's the CEO of Survivorship Now. For the past 10 years, Survivorship Now have been helping people document their essential information and decisions in a practical plan so families know exactly what to do if the unexpected happens. They also provide executor assistance services, so we help people clean up messes that they've been left with by people that they love who passed without a plan. Kristi's the mom of 2 chihuahuas. So you're a mom too.
Oh, get left out.
Now, when it comes to creating a practical plan, which is what we do at Survivorship Now, having an inventory of essential legal documents is probably one of the most important parts of it. And it's just crazy that people don't have wills. But that's what happens when you have a plan. You start to see what some of these holes are. So that's why we wanted to shine a light on this issue. It is that important. So now what I'm going to do is I'm going to pass it over to Kristi and Margaret to do the interview. We're going to turn off our cameras, and let's get started. Bye, everyone.
All right. Thanks, Karen. As a side note, Braun and Gresham provides expert legal counsel and practical advice for landowners, people who own rural property, and they do these services nationwide. Just wanted to kind of put that in there, because I had heard about them a few years ago, and we literally went seeking this particular expertise because we had a few clients who were dealing with issues of inheriting and selling ranches, and some who were looking at how to best preserve the ranches kind of, for their future generations. So this year, we did become partners with Braun and Gresham because they're a great fit for our clients with ranches and rural property. So when we started talking about doing a webinar on estate planning, which everybody has more questions about and more preconceived notions about, I thought it might be kind of a great service for all of our clients and our viewers to actually get down to some of the topics, some of the myths. It's a topic I found really intriguing and what actually keeps people from actually getting their wills done. I started going back over the studies since 2007 and compiling a list of the top reasons people don't have estate plans or not even have a will, and I confirmed that these are absolutely true. These are true. So, we picked out maybe a list of 6 of the common excuses various studies have come up with since 2007. I thought these would be a great topic of discussion for an interview with an attorney to really see what is myth and what is fact. And Margaret, just thank you so much for coming in and sitting in our hot seat and answering these questions for us.
Well, I'm glad to be here. Thank you so much.
Super. Well, this is a list of what we're going to talk about. You get a small preview.
Okay.
Okay, number 1, I don't have enough assets, so I don't need a will. Myth number 1. Number 2, I am sure if I died without a will, my assets will be distributed fairly to my family. So they're literally saying dying without a will is no big deal. Or is it? Estate planning is too expensive, I think. If you ever ask somebody, well, how much were you quoted? They said, well, I just know it's expensive. But nobody can really tell you what they're quoted. If I talk about death or illness, it's going to happen to me. Karen and I encounter this a lot. I don't know where that comes from. I don't know how to get started, so I don't do it. I was going to use an online or software will to save some money, but I'm not sure if it's good enough. So Margaret, those are going to be your 6 questions tonight on our hot seat.
Okay.
So let's get started with the first one. I don't have enough assets, so I don't need a will. Is that true?
Well, I would say that's not true. But I can understand why people think that way. You often think, I think our assets sometimes sneak up on us a little bit, Kristi, that, you start out with not a lot of assets, but you probably have some financial accounts that you're doing some savings with, or your business is helping you with those savings. And then you acquire a house, and you might have some jewelry, something like that. So I think one of the things is, even though you feel like you don't have enough assets to have a will, to justify a will right now, you very likely will have enough assets in just a few years. And then the other piece is not to just look at your will as something that transfers assets, because what your will really does, and what estate planning really does, is get you to plan and think about whatever you have, what's valuable and meaningful to you. It doesn't have to be a lot, but what's meaningful to you. Are you going to control who it goes to when you pass away? Or are you going to leave that to someone else, like the laws of the state that you're in? So I think you don't have to have some big threshold to have a will, especially if it's a long-term planning tool. I think there's many good reasons for anyone to get at least a simple will in place.
When I first read the statistic back in 2007 was the first time I saw this come up. I literally thought it had to be someone just filling a space, a statistical space. However, since I've been in this business, it has surfaced. People say, well, I don't really have anything, do I? I don't really need a will, do I? So I think this is a valid question, and and it is valid because you're saying that it's a future planning tool also. You may not have it now, but you may have it in the future.
And I think those of us who have chihuahuas and children know how quickly the future comes up. That 20 years passes with incredible speed.
Yeah.
And that's wonderful. There's a lot that can happen to you in that time.
Well, I think that's very valid. Not only is your will for now, it covers assets that you may accumulate, that you probably will accumulate in the future. So I think we're going to move on. That's an answer for that.
Even the train liked that answer.
Even the train. If anybody can hear that, the local train is passing through Austin. Dying without a will is no big deal, or is it? I have personal knowledge that this is pretty much completely not true.
I think it's a big deal on several levels. But this really is that question of, well, what are the consequences if I don't have a will? I'm really glad that you gave me this question right after that first one. If you die without a will, it doesn't mean that there's not a plan for where your assets or your valuable items go. Every state has a plan for you that the legislature put in place. We call that the No Plan Plan. And these are the statutes, the laws of every state that determine who are the heirs, and based on who the heirs are, what they get when a person dies without a will. So I would say if you really want to go without a will, maybe you need to read your state intestacy statute, which I know everybody loves to read, so that you have a reality check about where your assets really would go. Now, the other thing I'd say about is it really no big deal? I think it's incredibly expensive. And, especially if you don't have a lot, or the people around you maybe don't have a lot of assets, going through the probate process in a state, in many states, is just much, much more expensive when you don't have a will than when you do have a will. And here's an example. I've had a client whose spouse died without a will, and they had fully intended to get one, and it just didn't quite get into form and inked. And when the spouse passed away, it was clear it wasn't a complex estate, and it was clear that no one was going to really challenge how the assets were going to pass. There was a surviving spouse. There were 2 adult children. They supported the surviving spouse. But there were still some impediments to getting the property transferred in the right way. So they had to own a probate. They had to go through probate in Texas.
Mm.
And so even as a simple probate, and we got to use kind of a by agreement proceeding, which is even easier than most probates, they still had to have a declaration of heirship, meaning the court and the state law requires that the court verify that there are no other heirs, even though we all knew that the heirs were the spouse and the two children.
Mm-hmm.
The court still has to go out there and verify it, and they appointed another attorney to do that, so there were more attorney's fees.
Wow.
And then they had to publish, notice that there's this heirship proceeding, and then there's another publication that there's going to be a proceeding to designate an administrator. So suddenly their court fees for dying without a will are 3 times what they would have been had that spouse passed with a will. So it can be a real big deal to the people that you leave behind and are trying to make sense of your estate at a time when they're grieving.
Mm-hmm. Absolutely. I know that firsthand. When my brother passed away and we could not find a will, could not find anywhere, and his estate distribution was definitely not the way he wanted it to be, based on previous discussions. But we had no choice. Mm-hmm. Because the state of New Mexico had to determine where his things would go. So I would say good points. Yeah. They say, well, probate process in Texas is fairly easy if you have a will.
Well, and that's just it. At least in Texas, they have set up some mechanisms so that there's a lot of streamlining when you have a will, mm-hmm. And there's even some additional privacy. You don't have to list everything anymore. I think in other states, the probate costs can be significant, like mm-hmm. in California.
Oh, yes.
With or without a will. But I think in any case, law, the law is out there to protect people in so many ways, or at least that's the way it's drafted. And so the estates law is out there to make sure that people aren't trying to hide things from an heir. Mm-hmm. And that's why you have to go through this proceeding where we want to make sure someone neutral is out there looking for heirs. It takes more time. It
right.
takes more money. So with a will, you can really specify who's going to get it, and you don't have to go through an heirship proceeding.
Right. I think that's something a lot of people don't understand, mm-hmm. is how complex and how expensive it will become if you don't spend the money and time and effort right now. Right. It can be significantly more in the long run.
And I can tell you about time. Sometimes we don't value our time resource as much as we value having to write a check. So what I'm trying to say there is we're afraid to spend a little bit of money on the planning, but we don't realize that our time is worth it.
Yes.
And so the time it takes to work with an attorney and to draft a will is possibly a few weeks. The time it takes to go through probate with a will is probably 3 to 4 months. The time it takes to go through probate without a will is anywhere between 12 months to 18 months.
Wow.
And so,
wow.
So it starts really mm-hmm. absorbing that resource of time. And I think it's really thoughtful to think about the people you leave behind and how much time and hassle you're going to leave
Absolutely. For them. Absolutely. So time, expensive. It is a big deal to die without a will. Let's move on to number 3. Margaret, you're doing great at being in the hot seat tonight.
Thank you.
This is one I think that, I don't know if attorneys want to answer this or not. I get this a lot. Estate planning is too expensive. This one actually kind of floors me because I hear it all the time, but I guess being in this business, I've had a lot of exposure to the absolute chaos and the extra expense that can occur when no planning is done. So people say it is expensive. I mean, really, how do you address that?
Yeah. I think that is a real barrier for people coming into an attorney's office. And I'm really glad you brought it up, even though, I'm an attorney. But I think it's very realistic. A lot of people perceive that. And so it really follows on what I had just said. What is the true expense? what is the expense of planning early on versus the expense, much of which is going to be taken out of your estate. So it's still your assets that are paying for those fees and probate. Balancing against those excess costs that occur when you've died without an estate plan. So I hope that was clear. It's really sometimes we have to be willing to do an investment of time and money on the front end to not have our resources drained on the back end. So in that way, I hope that helps people kind of understand that there is expense involved. Now, too expensive. What does that mean? And I'm a big advocate of people should be a good consumer of legal services. And when I'm teaching students at the law school, that's one of the things I talk with them about. I mean, they need to be a good service provider to their clients, and I hope their clients are good consumers of legal services, meaning that they ask questions and that they're well informed. And so I think it's totally appropriate to call your friends and say, I'm thinking about doing an estate plan. Did you use someone, and what did you think about them? I mean, that's what I did when I needed a pediatrician, and that's really what I do almost every time I need a new physician for something. I get some referrals, and that's what I would do for a real estate agent. So why don't we do that for lawyers?
Right.
Start with referrals. Be willing to interview a few and really see if they connect with you and if they're interested in you and going to be providing services more than just a few documents, whether they're really going to listen to you. So I think if you're a good consumer, then the expense is going to be worth it, and you're probably not going to feel like it was too expensive.
We have, working with our clients, we help them do a lot of prepping and working with their attorneys. We have a section that we have our Assets Plus section. I think we've showed this to you before. Just getting together that information, and the more prepared you are ahead of time, you get more proactive, and you're not going to expect your attorney to go pulling this information. The more prepared you are, the less you're going to have to pay an attorney to gather this information. Is that correct?
I think that's absolutely correct. And I mean, the less potential there is for miscommunication, so that you have to go back and change something. One of the things we like to do as soon as we meet someone is we give them our own estate planning worksheet, and I think it's very similar to the worksheet you do. And it helps them kind of organize who's in my family, what are my assets, but I think what is really important is what are my goals. Let's not spend a lot of time on a particular type of estate plan if your goals direct you in another direction. Meaning, maybe your goals are more simple. I just want to make sure everyone's provided for in an equal way. Some people want an estate plan where their goals are a lot of privacy, that they want to try and bypass the probate process entirely, which you can do with a trust-based estate plan. You can increase the likelihood that you'll stay out of probate and have more privacy, and again, make it very easy on your heirs. So we think it's also really important to identify and have a discussion about what you really want, so that you're not spending money on something that you don't want.
Right. Absolutely. Well, these are great answers, Margaret. I love it.
Thank you.
Let's move on to number 4. And I think this is always interesting. If I talk about death or illness, it's going to happen to me. And this really isn't a legal question, but I hear it a lot, and it did come up in a lot of studies on why people don't get their wills done. And for some strange reason, people believe that if they talk about death or illness, they're inviting it to their doorstep. Karen and I always laugh, and she'll tell people, she goes, Kristi's been talking about this for 10 years, and she's still here talking. I'm still here. So do you encounter this? People don't want to talk about that.
We do. We encounter it some. I think what happens with us is by the time someone's made it to our doorstep, they're willing to be thinking about it. And so what I've noticed is what are some of the reasons that they actually get all the way to my law firm to talk with me about helping them develop an estate plan. And there's a variety of reasons, but one that's fairly common is they have gone through an estate, the death of usually a parent or sometimes a child or a sibling, and they've not just seen the process, like your experience with your brother, where the process didn't seem to be very fair to his wishes, but they've also realized that to the extent they didn't talk about illness or death, they were left in the dark by that person that left them behind. Mm-hmm. So I think they come to a conclusion that even though this is difficult for me to talk about, and I don't really want to think about my own illness or death, there's someone in my life that's so important to me, I want to do it for them. Right. And I know that there is an inevitability about this, so why not try and take some control over it? So, you know, it's much more of a psychology question.
Yes, it is.
Than anything. What we ask them, and we talk about some scenarios. We don't, you know, nothing terrible, but we have to take them through a few scenarios often about what happens if you pass away first, or what happens if you become disabled first. So we're having those discussions fairly actively. And I think what really helps people is to remember that those discussions are a very loving act toward the people you love. Mm-hmm. Having those honest discussions, being willing to explore this in order to help them in the future is really a considerate act.
Mm-hmm. I like that. It's a considerate act. You know, I was telling the story back when I first started my business. I had a couple that came in, mm-hmm. and they were in their 40s, early 40s, just getting married. They had been married, and she was pregnant with her first child. Mm-hmm. So it's a 40-something child. And I went through our plan. You know, I said we do extensive funeral planning. And I said, these are some of the things, and we get into the nitty-gritty on funerals, you know, so that you understand what a funeral looks like. Because a lot of people have no idea what's going to be asked to plan a funeral. And I noticed the guy turned as white as a sheet. And she got it. She mm-hmm. said, I had to do this for my grandmother, and I refuse to leave this for anybody. And, you know, and they paid for my services. They walked out the door, and I never saw them again. Oh, and I called and said, you know, I'm not understanding what's happening here. And she said, my husband can't talk about death, mm-hmm. apparently, and he needs to do this. He needs to get over this and get it done. And she said he needs to just put on his big boy pants and do it. And that was her answer to me. I said, let me give you back your money. And she said, no, he needs to do it. And I was caught in this position of a 40-something-year-old mm-hmm. who could not talk about death. Yeah. And flat couldn't even, you know, go there. So it was a very interesting topic because I thought, you know, a 40-something-year-old and you're worried about it already. That's very odd.
Yeah. You know. Well, and I think she's a great example of why she can talk about death. Mm-hmm. Because she understood from the perspective of the person that has to handle everything, handle all the details while she is grieving. And so I think you really have to put in your mind your loved ones. Yes. You know, hopefully they're going to grieve for me, right? And in addition, you know, do I really want them to be struggling with court processes mm-hmm. or with a lot of conflict with other family members? So that's the other thing. I think communication is really the best advice we can give anyone, whether they're communicating with us or mm-hmm. with you, but mostly with their family, is if you don't talk about this, the chances for conflict at the time of your death.
Yes.
Who gets what? Who is treated this way? What really should happen to the house, for instance? That conflict is just escalated. And the one way you can minimize conflict for your family members is to let them know what's important to you.
Yes, absolutely. I was on this radio show out in Houston, Straight Talk Money, a couple weeks ago, and I laughed really hard when the host said, "Let me tell you what, when people die, weird things happen." And and that is so true.
Yes.
That is so true. So, it's not really about you. So you need to get over it and consider the loved ones around you. So I'm sorry to throw that non-legal question
That's
your
okay.
way.
I hope it helped.
You took psychology at university.
I did. I have a psychology undergrad, but boy, that seems like a half century ago.
Okay, we're moving on to number 5. This is a super common question. People don't know how to get started. What advice can you give to people who want to get their estate plans done, and maybe a little of advice as to what to look for if they need to go in and have a review? Can you talk a little bit about that? I don't know how to get started.
I think we all live pretty busy lives, and sometimes I think maybe we overblow the amount of work it's going to take. And I think organizations like yours are really helpful about getting organized and knowing what you have to get started. That's why we send them this worksheet. It just puts people through an exercise where they start getting really a concrete, tangible piece of paper that tells them where their assets are. And once they do that, then they can start moving forward with the estate planning. And then, of course, we have those goals. So I think one of the ways you get started, like anything, is you just take it one step at a time. And I think, encouraging a conversation with a loved one, writing out what your assets are, even making sure your beneficiary designations are all the way you want them to be.
Mark that one.
And those are the beneficiary designations on your T's and your bank accounts and your mutual funds and your IRA and your 401k, all of those. You want to make sure that those are going to the people you want to go to. And that's a great start. You don't even have to come see me yet. But it gets you starting to think, if I designate this for my sister, do I want to designate this, this other account for my adult children? You get the idea that you have to start, balancing things, mostly because you want to have a say about who gets what. So I would say you get started by taking small steps. I would talk to other people. I love that. Have you done an estate plan? Who did you go to? Was it helpful? Get some information. You had like a second part to the question, which was, when do you review this? And I find I've been looking more like, what are those milestones that cause people to start estate planning? And so we've talked about one, and usually it's the death of a family member. They often realize, I've got to get started on this. I'll come in. The birth of children, and in large part because they start thinking about who's the guardian going to be. So that's a real milestone, and if you have small children and you don't have an estate plan, you need to get moving. Because then you're stuck with a court proceeding that will appoint a guardian. So why have a judge who doesn't even know you, and probably a social worker, make this decision? Why not go get an estate plan so that you can decide who the guardians of your children are going to be, and so that you can talk to those guardians and make sure that's what they want. So that's a big milestone, is marriage and children, possibly a second marriage. That's often. Changes in your assets. You look around and you realize it has been 10 years and we do have a big house now, or we do have a funded IRA. Do we need to start looking again at whether our estate plan really fits the assets we have? So for those people who say, I don't have many assets, I don't need a will, I think they need a simple plan.
Right.
And as they acquire assets, then they need to start looking a little more sophisticated at the plan they have. So those are just examples of those milestones. And I think plans do get stale after a few years, so it's worth looking at them. Laws also change.
Yes.
And so, a mere 5, 6 years ago, people were still doing a lot of estate planning to avoid the federal estate tax. Unless you have a very large estate, you don't have to do it that way anymore. So it might be worth looking at your estate plan that was written 10 years ago and ask yourself, does it really work in this tax environment? Or can I make it simpler?
Right. I think I'm seeing a lot of that with clients as we do reviews. These trusts were set up back in the 70s,
right,
80s. And I just go, well, you know, let's look at all of the assets and how does all this work, and you're not seeing the need for it.
Right.
So,
and there's a lot you can do with those trusts. Those trusts were set up to try and get assets out of a person's estate at the time of their death. There's, you know, with a very high estate tax exemption that we have now, you can consolidate that, and that actually means less paperwork.
right.
You know, and then I think also if you come to realize you have an illness, you know, oftentimes, I think that's part of my age, we have some chronic illnesses that we're taking care of, and we didn't have them when we were 25, and so that really requires you to think about your disability planning and, you know,
Right.
who is going to help me and who's going to help handle my finances if I become disabled.
Right. Right. Those are good points. Good points.
You know, just one other thing I just thought of, not only your life events, but if something happens like you have a will and your parents pass away and you've got them as beneficiaries of your will or named them in your will. I was talking with somebody the other day about this who realized that, you know, one of the parents was gone and they realized what would happen if they had passed away. The money would then go to places that they didn't really want it to go. So, yeah, so it's not just your own life events, but losing people who you have, you know, talked about in your will.
Right.
Yeah. And your beneficiaries.
And in your powers of attorney. I mean, I see that a lot, that sometimes they've got this power of attorney, and you don't look to your power of attorney that often. And I'm talking about your medical powers of attorney and your financial powers of attorney. And you'll have agents who have passed away,
Right.
maybe a spouse, maybe a parent, maybe a sibling. And so then you really don't have a power of attorney because your agent doesn't exist.
Right.
And so you really need to get those updated. So Karen, I'm so glad you mentioned that, because I think a lot of times what your assets look like change a great deal when you've inherited something.
Before we get to the next one, can I just say some people are sending some great questions in through chat, and we will be addressing those at the end. So I'm just noting them all. So if you haven't heard back from us, we're getting your questions, and we're going to address them towards the end. So thank you. Keep sending them in.
Okay. Margaret, you're on number 6, and if we have extra time, I've got a few more. This, in the age that we live in, is a common question. I was going to use an online or software will to save some money, but I'm not sure if it's good enough or not. It's one of the most common questions I get from clients. From people I meet, from audience members when I speak, this question comes up. Invariably, it comes up. You see the availability of a few online services and a plethora of software packages. So is it a viable option for the common person to use these kind of tools for their planning? What say you, Margaret?
Okay. So you asked if it's a viable option. And so, well, everything's an option. But this gets to that old phrase, you get what you pay for. And so I would say keep in mind that a will and hopefully other estate planning documents, I hope you all get that message by now that you need your medical power of attorney and a living will and financial power of attorney for disability. But all those legal documents can be complex. And if you don't have assistance from someone who understands them, you can end up drafting something that kind of doesn't effectuate your intention. It doesn't, I'm trying to not say it that way. I want to say that thwarts your purposes. I'm trying to think of a really good way to say this, but you could draft something that really doesn't create the distribution that you intended.
I think that is a great point, because I have seen, as clients have gone through this, is there are scenarios based on relationships that are not picked up through, if you're filling out a form online or in a software, and the relationships or the family dynamics aren't exactly taken into account. And I've heard attorneys explore that. You know, how do you want to do this? So the scenarios are taken a little bit further.
Yeah, the scenarios are taken further, and you might, in a will, do a scenario in one part of the will, but if it's not carried out consistently, if it's not correctly done in the definitions, if the definitions you use are not the right ones, and I know that these software programs do their best to explain per stirpes versus pro rata and all these kind of legal terms that we're still working with that are all written in Latin. If you don't do it consistently, that's what can cause the intention to go in a different direction. And so one of the things you're paying for is those extra hands and those extra sets of eyes that make sure you've gone all the way through the process so that your will is a cohesive package. And I think what you get from the online services and the software is a lot of risk that it's not going to be a cohesive package and that you've put in a great deal of time and it still doesn't do what you want it to do. So keep in mind that time and money balance. You know, it may be more money to get professional assistance, but it may be much less of your time. So I think that's very important. I have every year, and I have this year, I have people come in with, this is the will I wrote. And what we like to do sometimes with the online wills is to do a quick analysis and tell them this is where everything's going to go based on what you wrote. Is that what you intended? And their eyes get really big. And that's not exactly what I intended. So I do see these online wills periodically. I am sometimes hired to help unwind them when they're in probate, and so it's one family member trying to interpret it because another family member is interpreting the online will in a way that they don't agree with.
Subject, they're vague.
Yeah,
is
they're
what you're
vague.
saying. They can be too vague for what needs to happen.
And then recently I had someone who did, you know, an online power of attorney, but they didn't sign it. And so so there's always just those little errors. And so she just didn't execute it. And so it was great that she did it online. It saved her money, and she didn't really actually have a tool that she intended to have.
Right.
So those are, you know, some of the problem stories. One of the things I will do about going online is it informs you, and it goes right back to being a good consumer. And I had a client who said he wanted to have a trust. He had some rural land, and he said, I read a bunch on trusts. I'm going to drive you nuts with questions. And I told him, you won't drive me nuts. I'd rather you be well informed. And I think our discussion will be a lot better, and it'll be a lot quicker now that you are informed. So, you know, go online and see how things work if it's a source of information to you. But, you know, again, on that doctor analogy, sometimes I go online to get some information about what's going on with that rash that's all over my child, but I still take them to the doctor to see really what's happening. Is this an allergic reaction to some medication? Is it just a skin rash of heat because we live in Texas? Right. So I don't go uninformed to the professional, but I also don't really rely on WebMD to diagnose my child.
That's a good analogy. That's pretty much what I tell my clients when we come across, you know, our clients that actually have had the online wills. And
well, we've had clients who you could tell that they did the online forms and they forgot to change out their names.
Yes.
Remember that one?
Oh, yes.
It's like, good gravy.
I think what they did is they had a couple and they did one online, and then they went through and tried to copy it over, and they typed it in, but they forgot to change
the names.
The names. And like the executor was the person that was the will.
Yeah.
It was, you know, and so it was a very unusual. I mean, and I think people try to do this, and I always say, why don't you, if you do it online and you feel comfortable, go have an attorney look at it with all of your information. Just have them review it to see what you've got, and just to make sure that you're covered. Yeah. I mean, I think that just makes sense to do it. And if you've got somebody, like if you've got, you know, $500,000 in assets or whatever,
right.
What is, you know, $500, $750, or $1,000 to go in and look at this? People, I go, really? And you've got such a significant estate, but yet you don't want to have an attorney look at this.
And the failure, especially as your estate gets larger, the failure to plan, I don't think it's an estate tax issue, except for some very exceptional people, but it can easily become a capital gains tax issue to your beneficiaries when they go to sell maybe some of the assets or dispose of them, you know. So, you know, especially as your estate gets big, there's a lot of consequences about the way you're gifting, and having that conversation with an attorney is really important, kind of to think through all those scenarios.
I've been in on quite a few of those, so I wholeheartedly agree. You made it through 6 questions, and we have, we're out of time, so you are saved by the bell.
Oh, well, thank you.
You are saved by the bell, because I had a couple extras just in case we ran short, but I know this is a really chewy subject.
So we've got a lot of questions.
And we do want to, we want to hear from the people.
So we want to open up the questions. People have been submitting questions through the tool, and we're going to turn Margaret's camera on, and she is the star of our show who is going to answer these questions. I think Karen's going to moderate.
I'll moderate, that's right, which means I'll ask the questions and then I'll hand it over.
Okay, so I get to say something to these lovely people who are on the other side of the internet. It's really hard for me to look at the camera and not look at Kristi and Karen.
Yes.
So if you see me looking all over the place, and of course you see me talking with my hands, just have patience with me, because I just forget that I'm supposed to be looking right at the camera.
Right. What I'll do, I'll come sit right across from you too, so that might help if we're both here. Why don't you come over this way too, Kristi? Because it's a very unnatural thing to talk to camera.
Right.
So good acknowledgement. All right, so here we go. Question number 1. If you have a will, does the estate still go through probate in Texas?
Most of the time. There's a few mechanisms, like if there's just a piece of property, if it's a very, very simple estate, then you could avoid probate. If it's an estate that largely consists of only accounts with beneficiary designations, and you had that will as a backup and just to make sure that you were not going to be thrown into the intestacy process, then it's possible if everything can pass without going through probate. But it has to be a very simple estate, and there has to be those beneficiary designations in place on all your accounts. Now, the way to avoid probate is to have a trust-based plan. So what you do in a trust-based plan is you spend a little bit of that money you would spend on probate developing the trust. And so it's a little more expensive than doing a will-based plan, but you get a living trust established. It's revocable, meaning you can terminate it during your life. You're the trustee, you can be the beneficiary, and you can move your major assets into that trust. You can't move tax-deferred accounts, but you can move other, like checkings, CDs, non-tax-deferred mutual fund accounts into that trust. And so when the person, the settlor, the person who created the trust, passes away, that trust still exists. And that trust consists of some rules about how those assets are going to be distributed and what really happens next, and you never have to go to court. So if you want to have your family members avoid probate, and if you want to have the privacy of really passing without having to do any filing in a court system, then a trust-based plan is the better plan for you.
Great. So that kind of, and the next question is very similar, and I think you touched on it, is when is a will all that you need, and when do you need a trust set up? So you kind of touched on that, but
Right.
is there anything else you want to add?
Well, I think always try and remember, why is a trust better in my circumstances? So if you really don't want to have your family members go through a probate process, trust is a good thing. If you really want a lot of privacy, and it's not really a big issue for me, but apparently, like if you live in Hollywood and you're a celebrity and you have a will and all your assets and all your money of inventory gets filed with the court, and there are people that troll that and can make it really public. So I think if you have a high profile, you might want to have a trust because it's going to afford a family some privacy. Those are the main reasons. Sometimes it's just easier to manage a trust. So when would you use a will? And I often have clients come in, and we always give them the will versus trust discussion, and we talk about their goals. And I think if you have fewer assets, I think the families, the younger couples that come in because they have young children, and their main concern is who's going to be the guardian of these children and how are those guardians going to be supported with my assets, then a will plan can be just fine. Someone who might be single and knows many of their assets are in their retirement account, then the will really is there to catch anything, maybe windfall that comes their way, to make sure it goes to who they want it to go to. And so I think if your estate's more simple, a will is often a great way to go.
Great.
I think also, does the estate still have to go through probate in Texas? People are scared of the word probate, and probate in Texas is really easy.
It's easier than a lot of places. And I think I added to that scare because probate without a will, they have, and they've streamlined it some in the last, I think, 2 or 3 legislative sessions ago. I mean, I think they're trying to make it easier on people. But truly, if you have a will, probate's pretty straightforward. And you go in and you say, I've been designated the executor in the will, and you can be an independent executor, and you don't have to go back to the court for every move you make. And you're really, the timing that I gave you, which was about 4 months, is really to give you creditor protection. There's a 120-day period in which creditors could file claims against the estate. And so you want to let that pass. And so that's, I didn't touch on that earlier, but that's one of the good reasons to have a will, is if it puts you through a system that allows creditors to make claims, and if they're not valid, your executor denies them. And at the end of 120 days, no one can come back in and attack your estate. That notice period is over. And so there's some real finality with that.
Good. Ready for the next question? Do wills have to be witnessed and notarized?
Yes, in Texas, they do.
Okay.
I cannot speak to every state. It's a pretty serious document. And the reason you go through a notary process is to, ensure that, is to have someone neutral, ensuring that you understand what you're doing. I know that witnessed notarized wills, including in Texas, are easier to prove up in probate. So most of the time, you don't have to go find those witnesses to get them to testify. I can tell you on a declaration of heirship, we had to bring in witnesses that could testify and validate all the things that the family was saying. So that's another good reason. So if you have to get a few witnesses on the front end, it's much easier than getting witnesses on the back end.
Just so that's easier. Okay, another one. We talked about this a little bit about how often should you update your will, and we talked about major events that happen in life and that sort of thing. One thing we didn't touch on, I think would be good, is if people move state, that can really impact. And also, I guess it doesn't hurt to just kind of eye your will and your legal documents list every year or so. I mean, what do you think? What's the frequency?
I think, every year would be ideal, but I know even personally I wouldn't do that because there's so much going on. But every couple of years,
Take a peek.
Take a peek. And what we do try and do with our own clients is send out reminders after a few years. Do you need to look at it? Do you need to do any updating? So I want to be realistic, because everyone I know, if they're not busy, they're out doing wonderful things. We live in a wonderful place, and so I would much rather be, hiking or paddling on our lake or something than reviewing my will. Mm-hmm. And so I think it's good to kind of calendar it so that you're looking at it. And maybe what's really going to trigger it is if someone has passed away, or if you kind of migrated in your friendship away from someone who you thought would be one of your agents, then that's, those are the kinds of things to evaluate. Is this really working the way I still want it to work? Am I still close to that person or that in-law that I've entrusted so much to? You had another question about what about state to state?
Yes.
And it made me think of something different, but I will answer that first.
Yeah, go ahead.
You don't have to change your will if you move states. Mm-hmm. The states have the ability to interpret the will that you die with. And the court, where you're a resident when you die, not necessarily where you die, but where you're a resident, where your residency is the court that's going to do the probate or look at your will. And so a lot of people move around. The one thing I would say is if you go from a state and there's a lot of changes in the tax law, in particular, like there's no inheritance tax in Texas, but there might be an inheritance tax in another state, then you might want to think about that. You might change the way you do some of your distribution, maybe putting some of it in trust like that. So you don't have, you're not going to be in a really bad place if you haven't changed your will and you change states, but there could be some really good reasons to go see local counsel. The last thing it reminded me of is multi-state property is one of the good reasons to have a trust-based plan. So you've got the house in Texas, you've got a condo in Colorado. If you have it in a trust, again, when you pass away, the trust continues to exist. And so it's more of a real estate transaction to handle retitling those properties. If you have a will, then there's going to have to be some kind of probate process or court-involved process in Colorado to change the title. So that's why sometimes people who have property in multiple states will use a trust plan.
Good. Now, before we continue questions, because there are several more questions, I just want to acknowledge that we're at the hour. Margaret, you had a special you wanted to tell people about. Could we maybe look at those couple of things first, and then
go back
and drive that, Kristi, and then we'll come back to some questions. Okay. Then those of you, we want to respect your time. We said it'd be an hour, so thank you. And those of you who want to continue on for the Q&A, then we'll keep going.
People that want to stick around and have a few more questions, I do want to thank Margaret. We know that hot seats are always fun, especially when you get an attorney, because people really have questions. And it's just a fog when you kind of look at the process and you don't really know. So we want to thank you for being here. It's been a real pleasure.
Briefly, we do, at Braun & Gresham, we're a relatively small firm with very dedicated people. And one of the things we have is a landowner alert system, which is an email newsletter. As I said, we focus at our law firm on representing rural landowners, and we represent them in many ways, not just their estate planning, but on issues of condemnation and tax and how they use their resources, things like water on the land, real estate transactions, conservation. So we do a great deal. We do it for landowners. And so one of the things that we have is this email newsletter that is just bringing to your inbox a consolidation of different articles, some that we write, some that we've found, notices about different regulations or different new innovative technologies that might help a rural landowner. So if you're interested in the landowner alert system, you can go to our website or call us and we'll get you signed up for it. And it comes, I think, every 2 weeks. Having said all those good things about rural land, for those of you that aren't in Texas, we're located just outside of Austin, Texas. We're really in the suburbs, in a small community called Dripping Springs. So we still have very much an urban practice. And so don't feel like we're only helping rural landowners. We do a lot of estate planning for families and colleagues that are living in Austin and have nothing to do with rural land.
And I think we had a couple more questions.
We do. Here's one. How do I go about choosing an executor for my will? Any thoughts on choosing an executor?
I think that's an excellent question. And how do I go about choosing an agent for my power of attorney? How do I go about choosing guardians for my children if that's your situation? So that you need to think about what are the tasks that person is going to have to do. And so the executor really is the person that steps in, following the rules that you provided in your will, and goes through the court process, which hopefully is not too difficult, and make sure that everything is collected into your estate, and then that your debts are paid, then your gifts are distributed. So that's the process it goes to. So if you have any secured debts or obligations, those come out of your estate before the gifts are made. And so that's what the executor does. So you want someone who you trust and who you feel you trust with information about you and about your estate, who you feel will do what you've asked them to do, and who you think is capable. So a lot of times people will actually choose executors that live a little closer to them. Mm-hmm. You know, even though their closest sibling is, you know, in Philadelphia, but, you know, I still have a good friend here in Austin and I trust her, so I'm going to have that person be the executor because it's going to be really hard for the person thousands of miles away to do it. So you just need to think about what they do, how well you communicate with them, and whether they're going to pull through it for you. We always have clients identify 2 or 3 successors for their trustees, for their executors, for everything, for their agents on their power of attorney. And we give each agent or executor the opportunity to back out either because they're incapable or they don't feel they want to. So I think that respects that sometimes people are not in a place in life to take on the job, even though when you look at your will, they were in the place.
Right. So is there an option if you don't want to choose a person like a friend or a relative or whatever? Mm-hmm. I lived in Australia for years, and one of the states is New South Wales. This is a New South Wales public trustee. So you can actually name the public trustee, this government entity, to handle the whole process. Yeah. And they do. Is there anything like that here in the States? Or
no, there's certainly private trustees, you know, and certainly there are trust companies, and we, law firms, lawyer, you know, you can hire or retain someone. You're going to need to plan on what the cost of that is going to be, but it actually could very much be worth it. And especially if you've planned your estate well, there's not that much work to do, then maybe, you know, keeping in mind that your close family members are grieving at the time of your loss, maybe it is good to have a neutral handle it.
Yeah. And actually a follow-up question just came in that's very similar to this, which is this person has a father as the executor, but is worried that the father would be overwhelmed by their estate. Is there any done for you services? Someone who can help you? I mean, I know that's one of the things Kristi does.
I think that's what Kristi
does. Executor assistant services. But yeah, I would be completely overwhelmed.
Right.
If in some situations of people I know, it's like, don't pick me.
Yeah, and I think Kristi's a great example of that. I think there's more than just one person out there that really needs her services, which is, you know, why you've been able to develop this. And I think sometimes, Kristi, what you're able to do doesn't come with some of the institutional costs of using a bank or a law firm. So I don't mean to turn away business, but let's be good consumers, and let's use the lawyers for developing the documents, but maybe a service like Kristi for really getting the executive services done.
And would those costs come out of the estate? So if you hired someone to do executive assistance, does that cost come out of the estate?
Yes.
These questions keep coming
in.
That's
a good question.
That's wonderful.
Great. Thank you.
Here's one from DC from Bruce.
Yes, I do. Do you want to read that one?
Yeah, let me read this one came in. I was named financial power of attorney for my elderly father, but his bank is telling me that they require that my dad fill out their firms.
Yeah.
Probably forms.
Yeah.
Yeah. Probably forms, yeah, the financial power of attorney. And this, I know, I just did this for my brother. In addition to the power of attorney form, they will give me access to his financial account. Can the bank do this?
The bank can do this, and Vanguard's going to do it, and Fidelity's going to do it, and any of these large institutions.
Stanley, yeah.
And I am really glad you asked that question, because that's something I know really well and I forgot to mention to you all. You still want to have that power of attorney from your father, because it gets you in the door at the bank. But we tell all our clients, everyone has their own form. They want to see it on their form, and so this gives you the authority to complete their form. But do anticipate that there's going to be a different form for every institution. And it's incredible, because it's the Texas form, and I think most states have a statutory form. You know, so it's not like you're being that creative with the power of attorney. It's a very straightforward document. So we want you to make sure you have it filled out right. But it often is just what takes you to the next step, and then that institution wants you to complete their form.
Actually, can we build on that? Because we heard a personal story from someone who went through this. He had the power of attorney, and he uses his middle name as his first name in life, right? So his driver's license, let's say his name was John David Smith, and his driver's license said David Smith, because he always goes by David Smith. But the form said John David Smith, and they wouldn't accept the David Smith because it didn't match. And he had to go back and forth to this bank 3 or 4 times. So that might be a little tip, too, is to make sure the name
that's happening now.
Don't you just want to scream?
Yeah.
I'm sorry.
Don't think about my sister. She goes by her middle name.
Now I'm really in the hot seat, because you're making me so mad. We do make sure that we have also known as on our forms. And I think, you know, look for that. So it's John Smith, also known as John David Smith, also known as John D. Smith. I like more efficient language, so doing that makes me a little crazy. But I think your example is perfect, that it helps you deal with institutions, right? That's what that power of attorney is helping you do, is interface with these institutions. And the other thing you need to do is, when you start getting that runaround, is you need to try and find someone who feels comfortable enough to make a decision, right? Yeah. And sometimes you have to go to different branches. Sometimes you have to ask for the manager. Sometimes you have to call customer service. I think a live person is much better than someone over the phone. But go looking for your advocate in that institution, because they're being unreasonable.
Yeah. Yes. Yeah, this guy was very well known, extremely reputable, and he could not believe the hoops he had to jump through. Yeah. And I know, Kristi, you were experiencing that, because I was with you when you were having the runaround.
Yes.
What should have been half an hour at the bank was 2 hours. Like, it was Kristi.
And then I had to go to a different bank and have them redo it.
Yeah. And it was only because you knew what to look for, because what they tried to have you do would have cost a lot of money from a tax perspective, right? I remember you came out fuming.
Well, she was on the hot seat, too. Yeah, I get on the hot seat.
She had a hot seat.
This is a real interesting thing, speaking of banks and bank deposit. Can I add somebody to the access list to my safe deposit box without going to the bank with me? And this I'm seeing is different from bank difficult. Yes.
And so I don't feel really equipped to answer your question. One of the things I know, which is still shocking, is that they use a paper card system for so many safety deposit boxes. And so maybe that's the bank's rationale for having someone in person. Think about getting a fireproof safe.
Well, my sister recently added someone to her safe deposit box list, and she did not have to have that person go into the bank with her. So, but it does vary by bank from some of the research we've done and some of the things that our clients have told us.
Well, and the reason I am so aware of the card system is that they couldn't find the card for my father's safe deposit box when my mother was there. She was on the card. And it was literally, I mean, of course, they opened their safe deposit box 50 years ago, so it was like stuck to something.
Oh, wow.
We had to try so many things. Just get them to work with us. So, yes, I'm sorry. I wish I had a better answer to that.
Well, I think it is bank to bank, because when I did this, I had a totally different scenario where my family had to come in and we had to reopen a new account for the same box when I added them to my box.
Right.
And it took us quite a long time. So it varies bank to bank. And I think banks interpret things differently a little bit. There's a little bit of interpretation. Their rules and procedures are different. But I would say if you had to do this, is go to your bank and find out.
And find out what their procedures are. You know, if you're writing your own will, try and develop a relationship. You know, have that personal banker, which some of the banks provide. It's no cost to you. We usually try and keep a list with your will. We give you a pretty portfolio that's got all your documents together, and we have all your kind of contacts. So your family members, if you pass away, could go back to that person who's been your personal banker, assuming they're still there. But, I mean, it at least gives you a leg up.
It's good. That was the last of our questions.
That was?
So, yes, if anyone has any last questions, now would be the time to type them in. No pressure.
No pressure.
We've got Margaret for 2 more minutes. Now's the time.
Well, thank you so much for having me.
Oh, thanks.
Not that that's
so
a closing
amazing.
comment, but I really appreciate the opportunity to do this with you.
And until then, until we meet again, be ready to hear some more seminars and webinars that we'll be having coming up starting again next month.
Yeah, just visit survivorshipnow.com, and under our events you will see our next webinars. But these types of training webinars are something we're wanting to create to cover a lot of these common areas where people have questions and they don't know where to get answers. So that's what we're doing for you. Thanks, everybody, and thank you so much, Margaret and Kristi.
Thank you.
Bye, everybody. Thanks for spending your night with us.
Bye-bye.
Bye.